Good morning, everybody. Welcome to our August webinar with the title, Whose Scheme Is It Anyway? We just want to introduce, first of all, Zerlinda van der Merwe and Nicole from TVDM Consultants. So thank you for joining us today. Just want to... Okay, I'm going to do the intros quickly. Firstly, we're going to introduce Willie Roos from Stratafin. Willie is the founder and CEO of Stratafin. Willie holds a BCom and BProc degrees from the University of Johannesburg. He practiced as an attorney and conveyancer until 2008, whereafter he became involved in sectional title management. During his time as the principal of a managing agency, Willie became interested in community schemes financing and started working on the business and actuarial model of which Stratafin is built today. Today, Stratafin has assisted hundreds of schemes throughout South Africa and placed funding exceeding 300 million into the hands of schemes. Welcome, Willie. Zerlinda graduated from the University of Stellenbosch with her BA, LLB, LLM cum laude degrees while completing her LLM thesis, specifically focused on the constitutionality of sectional title rules. After graduating, Zerlinda joined Pam Golding Property Management Services as a managing agent. Following the practical experience, Zerlinda completed her articles with Marina Costas of BBM Attorneys, followed by her appointment as a specialist community schemes consultant with Professor Graham Paddock at Paddock's. Before she co-founded TVDM Consultants, Zerlinda went back to her roots as general manager of PGPMS. Welcome, Zerlinda. Nicole joined the TVDM Consultants team at the start of 2021 after finishing up her LLB at Stellenbosch University. She recently completed the SA Legal Academy mediation course and is now also an accredited mediator. Nicole completed her LLM at Stellenbosch University, focusing on comparative apartment ownership, advanced company law, mediation, and specialized dispute resolution techniques. Nicole's also a member of the Golden Key International Honor Society as a top academic achiever in her respective field of study. Her favorite community scheme topics include pets, solar panel installation, and the drafting of management and conduct rules. Welcome, Nicole. And I'm going to hand it over to Willie.
Thank you, everybody, and thanks for the opportunity to again have a chat to you all. Today is going to be a bit more informal. We've decided that we're just going to have a chat about whose scheme is it anyway. It is quite an interesting topic that we have picked, and we're definitely going to discuss some examples of what Zerlinda, Nicole, and I have found in the field and in practice, and what we have seen over the last couple of weeks and months. Just one other thing, Stratafin with the TVDM group has done the trustees training portal. We have recently seen that we've reached 2,000 trustees that have done the training on the portal. So we're very happy that we have been able to reach so many people already with the trustees training portal. And I just want to thank TVDM again and these clever ladies from TVDM. You see, they all have LLMs and top honors and so forth, the clever people. So thanks, you guys, for joining us, and thank you for what you're going to share with us. So, Zerlinda, I'm handing over to you from here.
Perfect. Thanks, Bill. It's all to you and Dr. Karen Durham that put the training material together. It's so exciting to know that we've reached 2,000 trainees. That's very, very exciting. And that's just, one of the many, many platforms that's available to people, both free and with minimal charges. So, the education or the need for education is most certainly, never going away. So this topic originated from a matter that the three of us worked on together. So Nicole and I have been working together for a group of clients, and we got Willie involved because, number one, it was a matter with his conveyancing background that he'd be very suited to, his litigation background, and then because he was based in Johannesburg and the scheme being in Johannesburg as well with us in Cape Town. So Willie, in his normal style, got dug straight in. He spent hours and hours preparing and all those fun things, and it was about two body corporates pretending to be one. So they were administering and managing themselves as one body corporate. And when we dug deeper, it found out that they were actually two completely separate body corporates. And it was very, very difficult for owners to understand that where they've been doing everything times one, they should actually be doing it times two, even though it may be seen as a duplication of fees and responsibilities. That's just how it was, which got us talking about a couple of other matters that we've been working on either together or individually. And, the thought crossed our minds that it might be a good idea to look at some of these examples and look at how a body corporate can be set up. And more importantly, look at how a multi-layered development can be set up. So body corporates in a homeowners associations in a master homeowners association, body corporates next door to each other as being tied as one or not tied as one, but looks like it's one. The developers are becoming more and more creative, it seems, with regards to the types of developments that they're doing. And there's requirements of having quite unique rules. So we thought we'd start right at the beginning. And Willie, this is more of a conveyancing thing than anything else, where you are the expert, is just at the establishment of a body corporate. So, the bog standard body corporate is where you have a developer and an IRF, and you have a set of management rules and conduct rules. And if the developer doesn't want to change the rules, they simply have the prescribed management and conduct rules, or sometimes they change the conduct rules but keep the prescribed management rules as they are. But very important to note, at the establishment of the body corporates, there are only a very limited number of management rules that can be changed by the developer. And if the developer does want to change other rules, they have to follow a more creative process, let's put it like that. And there's so many steps to follow that if one of these steps aren't followed, the entire development is set up incorrectly. So perhaps from a conveyancing perspective, Willie, you could just give us, how it was under the Sectional Titles Act versus how it is now with regards to setting up, different buildings in a body corporate. I know there was the requirement about it being, one IRF or two IRF next to each other. Do you have some more comment there?
So the discussion that we had yesterday regarding the old act and the new act, in the old act, all the buildings had to be connected. So that was something that is very important. And it was like what we would call now a flat type of building where everything is connected. There are interconnecting walls and so forth. So that came to an end with the introduction of the new act, and you now can have separate little complexes or separate sections inside the complex that are not connected at all, and they're more functioning like individual properties rather than one single building. So I see Aubrey is also on the group here today, and Aubrey and I did a discussion previously about duets. That are sectional title schemes that have their own little stand, and they function as separate little units, but they're two little units that are actually one little scheme. So those things then came into existence with the new act. And as a result of that, we now see that there are multiple different ways of setting these things up. We are involved, and Aubrey was also involved in that specific scheme, in a scheme just past Nailstroom, the old Nailstroom. It's now called, I forget. But in any event, a scheme where you have a sectional title scheme, and then on the inside of that is a share block scheme that owns certain of those units, and they're all separate. And then they've gone as far as utilizing Section 25 of the Sectional Titles Act, the right to further develop, to actually create urban. So there were these urban created in respect of Section 25. So the people that bought them actually become developers, and they have the right to further develop later on, but they are separate stands in essence. So there are very creative ways that the developers are currently doing these things. And this specific scheme that we were involved in, the three of us, you had two different urban that were never interconnected. So one would normally have, in the old days, one would have utilized a consolidation. So you would have consolidated those stands, and then you would get your sectional title plan drawn up and registered for that specific scheme, and all of that would then be on one scheme. Alternatively, one would have notarially tied these urban together so that they always function as a separate, as a single entity. So those were the ways that they were done in the past. What we now see is that developers set up two different schemes, and the entrance of this specific scheme actually is in a third scheme, if you guys can remember. So actually you have three schemes that function almost together, or needs to be functioning together to be a single scheme. And in this instance, these two schemes then actually have one single budget, one single set of trustees, one single managing agent, but unfortunately, two different sets of needs. And I think that is where the problem arose. We are involved in a different scheme in Pretoria, where they are two large flat buildings in Sunnyside, and in the middle, the stand, or the portion in the middle, the common property in the middle, the swimming pool and the clubhouse and so forth for both these buildings are on there. And they're also two different, completely different schemes, but then they function as one. They also have their budget together, one set of trustees, and so forth. But also two completely different buildings. The one is a face brick building. The other one is a plastered building that requires a lot of painting and maintenance. So different needs for different schemes. And I think that's where the discussion came from, where we said, okay, let's have a look at what the Act requires, what happens in practice, and let's discuss this a bit and have a chat about it. So yeah, so in terms of the old Act, had to be the single structure. Now not necessary anymore. You can now have little separate sections, separate buildings, separate things. We've also seen some schemes where you had one homeowners association, and then that homeowners association is now becoming the master homeowners association. And then on the inside of that homeowners association, there are various other smaller or sub homeowners associations. We're currently dealing with one where we will have to determine how we're going to sue, because you now have money owing to the master homeowners association that was initially owed there, and then the secondary homeowners association was set up, and there's money owing to that as well. And now Stratafin gets involved in that, assist with finance, and then we need to determine, are we now doing two summonses? Are we doing one summons? Can we do one? So very interesting things that we are seeing happening in practice.
Yeah, I think before I hand over to Nicole, one of the things that I think our clients get a little bit upset with us is when they give us a scenario and they say like, I've got a problem with the trustees in my estate. They're not letting me do X, Y, and Z to my home. Like you immediately start thinking, okay, trustees means body corporate, estate means homeowners association, home means homeowners association, because you wouldn't refer to your unit as a home, surely. So it's so important to understand the right terminology to use in all of these instances as well. You know, who are you a member of? What is the nature of your actual scheme? Who do you report to? It's where are your levies payable to? What are your levies covering? Nothing in community schemes is as simple as, I'm an owner, this is my problem, give me an answer. There is so much more to it. And now you're dealing with multi-layered schemes. You really sometimes, and I'm sure that Rosina and Nicole think I'm doing it because I'm old school, but sometimes the only way I can understand a setup like this is if I take a blank piece of paper and draw like a little map for myself. So I draw my little homeowners association with my multiple entities inside, and there's arrows going left, right, and center, and eventually I figure it out. But without having that visual aid, it's sometimes very difficult to understand who's who in the zoo and whose scheme is it anyway. You know, who are the members of it and who are the trustees of it and all those fun things. I know that Nicole's latest passion project is homeowners association, so maybe she would like to start us off on the next slide, if you'd like to, unless you've got something to comment on this particular one.
No. I think what I'd like to say for this part kind of ties in with what we're saying. So obviously establishment of a body corporate is very nicely regulated by the Sectional Title Schemes Management Act and the old SDA and all of those things. And a big problem that happens, at least on my side and in our neck of the woods in Cape Town and the Western Cape especially, is, you know, how do we actually start an HOA, a common law homeowners association? Of course, with the non-profit company homeowners associations up in Gauteng and few in Durban, those places, it's a bit easier because you can, of course, you've got the Companies Act that helps you a little bit, but also not really so much because, of course, the Companies Act was drafted for the purpose of actually regulating and managing, you know, operational companies. And all of us that, you know, have had the pleasure of living in an HOA will definitely know that it's not like a company, whether
Nicole,
it's
can I just jump in? Yes, I see that there's a problem with the sound.
okay.
So let me just see. Maybe the problem.
Ooh. Is the sound a bit better? Okay, cool. Maybe the sound's a bit better now. We'll wait for feedback from the chat. Okay. Okay, cool. So I'll just continue. Sorry about that, folks. All right. So let's start with the Common Law Homeowners Association. So especially when you are looking to, as we discussed earlier, with these multi-layered developments, and especially when Willie mentioned, you know, two schemes now come together and maybe they want to form an association for shared common services like the security entrance, or maybe there are lovely common property gardens in both schemes and they're like, you know what, it's actually easier if we just get the same contractor to do the work on the same days. However, if you are bodies corporate or multiple schemes that would now wish to join or create a master association or something along those lines, very important to note that this is quite difficult once schemes have already been established, because you would need the written consent of every single owner that you are attempting to now bind into this new homeowners association. And it would be a condition that would now need to be registered against everyone's title deed, which is also something worth mentioning. And then with furthering on the common law HOA principle, to actually open and establish the scheme, you will need to submit the constitution to the relevant local municipality or council for their approval. Now, I say approval in inverted commas because once you register the scheme and all of those things, you have to send through the governance documentation and all of those things. In our experience, or at least with the Western Cape municipalities, they don't really pay much attention to those constitutions as long as you have the important clauses that deny the city or council of liability, you know, with regards to anything within the homeowners association. And then, you know, it just goes through the process of through the relevant LUMS department, which is the Land Use Management Service in the municipality. And you register the scheme that way, and it's kept on record at council. And also, of course, unfortunately, you need to register your scheme with the CSOS and pay your CSOS levies on a quarterly basis. But essentially, from the registration point of view of a common law homeowners association, that's really how you go about it. And then, of course, for the non-profit company homeowners association, you obviously have to go through the submission of the company to SIPSI and get the relevant documents from SIPSI in that regard, as well as also, unfortunately, registering the scheme at the CSOS. Yeah, so I think that's where I'll start off with the registration and establishment of HOAs. But it is quite a interesting topic, I think. It's definitely our most unique and interesting questions that I come face to face with are always around homeowners associations, like who is the member, how did you determine what the levy must be, who's in charge. Sorry, I didn't sign up to be a part of this association is my favorite. So yeah, I think that would be a good basis for us to kickstart this one.
I know that towards the end, Willie's going to be chatting about, the importance of having your title deed conditions, other than just a clause in the Constitution or the Memorandum of Incorporation, or even just the clause in the sales agreement, because we're all very, focused on what the sales agreement says. We sometimes forget that the sales agreement isn't the be all and end all, and is only binding between the seller and the buyer. But, other than having a homeowners association, that's a bog standard homeowners association, as Willie mentioned earlier, you could literally have a master homeowners association or a property owners association or even an owners association with different sub-associations or homeowners associations underneath. And very often, even if you have a common law homeowners association that's established in terms of your municipal bylaws or a CIPC registered NPC homeowners association, it's still possible to have a sub-association within that or under that umbrella. I like to think of it as an umbrella like the master HA, that you could still have an association that's founded not by local authority or by statute, but simply by agreement. So you could have the founders that are members of the initial or signatories to the original constitution, and this could be in any province, that they are bound to the constitution, and any successors in title are bound to the constitution. And sometimes the work of the master is delegated to the sub-association. And in that sub-association, you could then have a homeowners association or body corporates, or under the master, you could have body corporates, or under the master, you could have freestanding properties. So it gets incredibly complicated. I remember back in the day when we were training the CSAR staff, we looked at Century City or Canal Walk as an example in Cape Town. Most people know Century City, and that has a property owners association. It has precincts. It's got bodies corporates. It's got commercial entities and hospitals and schools. It's got freestanding properties, a shopping center, parking structures. It used to have Ratanga Junction as a recreational area, and now it's developed to its fullest extent. It is such an interesting example of this multi-layered development. So yeah, very, very interesting to look at the difference between a body corporate and a homeowners association, but how the two can mix together. And then I think the next topic is where the homeowners association type of governance documents can actually be the rules for a particular body corporate as well. Willie, I don't know if you'd like to comment on this whole Regulation 6 setup of a body corporate from a conveyancing perspective, or when you guys are taking on a scheme and you ask for the management rules and you get a copy of the constitution. I know the banks like to refer to a constitution of a body corporate that obviously won't be a constitution unless there's this Regulation 6 setup of the body corporate that the developer has put into place. You just on mute, eh?
Sorry about that. So I was saying, I'm going to leave it to you clever ladies that deal with this and my compliance department to deal with that. It does not really fall within my expertise. I think you guys know far better than what I do. So Nicole, I'm gonna pass it over to you.
Perfect.
So I'll be
your
honest.
field of expertise.
Yeah, I'll be honest, and Zerlinda knows this. As Zerlinda mentioned when we started, if you are a developer, and this is especially, we find that this is always extremely popular with a body corporate or which is now an association. It's very important when there is a right to extend in place, because often what happens, and it's becoming more and more popular, I'm not sure in your neck of the woods, Vili, but in Cape Town, it's becoming really, really popular. Developers don't seem to be, or at least the developers we work with, I think they're generally very, very good people. And what happens now is when they're developing new developments, they have a lot, or I like to think they have a lot more interest and foresight into how things are going to be managed, from like a collections and a voting and a contributions perspective, especially when they are thinking of retaining units themselves. And that's becoming super, super popular. Zerlinda and I, we were working on a really, really interesting and difficult matter recently, where it is a body corporate, but essentially they are totally separate. Okay, so they can operate totally separately and independently, but there is, you know, of course, just shared common property between the two, let's say, components. The problem is that even though it's going to be a multi-unit body corporate, the developers are most likely going to be retaining all of the units. So now we've got two owners who are going to be, you know, two owners in a multi-scheme, in a multi-unit scheme for the foreseeable future. And of course, they are very concerned with, you know, everyone having equal rights, but making provision for themselves, but also making provision for if they sell in the future and there will be multiple owners moving forward. It sounds quite crazy and like it's very confusing, and that's because it is. So as soon as they came to us and they said, you know, we want a component scheme, so we'd like a split, we don't want anything to do with each other. They are on a consolidated earth. So as Willie mentioned in the beginning, the two components are tied together. It's the same earth, same body corporate, but from a management point of view, they don't really want anything to do with each other. And I must say, in Cape Town, again, I'm also finding that's becoming very, very popular with mixed use schemes. So when you have a residential component and a commercial component from the outset, the developers have foresight to say, you know what, I've been involved in situations like this in the past. I know there's always unhappiness and uncertainty when all members have bought, and there's a bit of there's always an us versus them in a residential and commercial component mixed use building. So to get away from that, you go with a regulation for constitution. And essentially, it's not a constitution like a constitution in a homeowners association. It almost reads very similarly to the format of the prescribed management rules. However, it allows developers specifically, because now for a constitution, we are looking at before the scheme has been established. It gives the developer the power to put in different, specifically using the word different management rules, specifically to manage things like voting rights, contributions, liability in the scheme across the different components / members, and then getting that approved at the CSOS before it opens. So now what's important to note about a regulation 6.4 constitution is that there are only certain management rules that can be completely disregarded, and they aren't great. It's I think I stand corrected, but I know that like the chairperson is one, and those types of things. But where it really comes into play is it gives the developer the ability to put in additional rules, so not rules that are contrary to the current prescribed management rules in place, but it allows you to put in extra protection and extra regulation that might not have been previously allowed by the forum that quality assures and approves governance rules. So I'm not sure about anyone else's experience, but in our experience at TVDM, when you submit an amended set of management rules that are, you know, following the process of the prescribed set of management rules, the CSOS are very, 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 very strict about deviating from that prescribed set of management rules, because in their opinion, they believe that the prescribed management rules covers everything it needs to cover. There's no need to deviate from it. And generally in our experience, they've only been very open and accepting of these different types of management rules in these regulation 6 constitution setups. But again, I must emphasize that it's really only something that is practically possible and doable to set up before you establish the scheme.
Can I just quickly jump in here? So we've been involved in a matter in Rosebank where you have a scheme that consists of a shopping center and then a hotel. and these two function then separately, like what you have explained now. And the idea was to place this whole scheme under administration. And once you've got it under administration, then you have a single person that then have to agree to this. So then it becomes possible after the fact, because you don't need each and every owner's consent in that regard. However, when we wanted to do it, CSOS was of the opinion that the court order did not allow for it. So we are currently busy with an amendment of the order to include that, so that one can actually move to have that done. Because as you say, it is almost impossible to have it done after the fact. And we are trying to do that. And if you guys are, I mean, you guys are well aware of the facts of the building in Lovo, that we're also dealing with jointly as well, where we also have a mixed use. That is also something that one would want to introduce there, because you do have the hotel portion, and you have all then the shop portion, and then the residential portion, and so forth. So that is definitely something that should have or could have been used there, and it would have stopped half the problems that we're experiencing in respect of that scheme as well.
100%. Before Zerlinda says anything, I just want to say that on my very first day at TVDM, my very first consultation was to discuss a Regulation 6 constitution for a hotel setup body corporate in Cape Town. And I just remember thinking, oh my gosh, like, what have I gotten myself into? I have no idea what anybody is saying, like, what's going on. And then
was it the same developer?
Yes, it was the same developer.
Okay.
And then I said then something Zerlinda said really put my mind at ease. And I think that this is something that will help a lot of people on the call, is that the Regulation 6.4 Constitution, and that the whole concept of this component / layered scheme is definitely the hardest thing to wrap your head around in sectional title, because unfortunately the act doesn't really help you much, and you only know what you know with engagement, with like our engagement with the CSOS and how they handle it and what they're going to take, what they're not going to take. So for anyone who is thinking about doing it, I definitely recommend getting advice beforehand, because I know, for example, I've seen so many schemes where they've tried to set up like a Regulation 6 constitution, or they've actually tried to set up a homeowners association, but it actually turned out that it was a Regulation 6 constitution and the scheme was a body corporate. But like for years and years and years, they've been operating as an HOA that just has a body corporate inside of it, but that's not the case. So yeah, it's really complex, and it's definitely something that I find is either not set up 100% from the start, which obviously makes it incredibly difficult to pick up the pieces moving forward. But yeah, to even start it from scratch is also really difficult. But in saying that, it's definitely the best way to handle component split, multi-layered like developments, where it's kind of just oh, well, we're all just in the same place, but we actually have nothing to do with each other. Yeah. Cool.
And the reason why you would find that is because their needs are completely different. And why you would want to do that, because you have your residential portion, and they've got specific needs in respect of what they do, and then you've got your hotel portion that have completely different needs and their own security and everything on their own. And it makes it very difficult then to deal with levies if you don't layer this in some or other way. So yes, that is definitely the way to go. But unfortunately, we haven't seen too many of those set up from the start. I think we do see them now in respect of the larger developments that we see with developers like Baldwin and so forth, because they do have the creche and they've got the restaurants and so forth. So then it becomes necessary in those developments to do so, and to regulate that and to determine levies in the correct way.
Well, Nicole's got another interest in, other than homeowners associations, is in short-term letting. And short-term letting is a real hot topic at the moment. I see she's pulling her face. We're trying to get her onto the radio to chat about short-term letting. And when we spoke to a developer client fairly recently, we looked at something like this as an alternative to short-term letting. So to almost revert back to the old rental pools, to almost operate like a rental pool, but rather as a component of the body corporate, doing a Regulation 6 or even doing a Section 11.2 later on, changing the rules. So although it's almost impossible to do the Regulation 6 or retrofit a scheme to do the Regulation 6, something similar could be achieved by using Section 11.2 of the STSMA, previously 32.4 of the STA, to create this component. I had a client this morning that asked, they need to repair, or rather replace, a system that serves the entire body corporate except for certain sections, and they're wanting to know if these sections should be excluded from the contribution. And I said, the first thing we have to look at is if you've got this rule in place. And when the rule was not there, I said, well, it doesn't matter if somebody can't access it, can't use it, doesn't use it, they still have to pay towards it. It's like having a swimming pool in your scheme, but never using it because you've got your own pool in your own exclusive use area. You still have to contribute towards those expenses. And
or the ground floor unit not wanting to pay for the lift.
Yeah, 100%, 100%. And that's normally this mixed use scheme, commercial versus residential, commercial on the ground floor, residential on the other floors. There's a security issue because security only services certain floors, and parking, and you name it. So it's so important as to how a scheme is set up, preferably Regulation 6, if not, a Section 11.2 rule. CSOS is also a lot more understanding of this constitution element for a Regulation 6 as what they were. I suppose, Nicole, you're busy dealing with them right now with regards to some amendments of a constitution that they require, but it doesn't seem to be as foreign a concept anymore, provided it's done right at the beginning with the developer. But it's not something that can be rushed. It's not something that there is a template for, and it's quite complicated. Mike has pointed out an EUA, not the way around this. Yes, you can use the EUA route as well. So there's so many different ways to get to the same, goal at the end of the day. Sorry, Nicole, for that being your first experience in community schemes. I remember it now. I think I met you and everything physically the first time at this development site, where we had to go and wear our hard hats, sort of like, hi, new employee, welcome to this to this intensive consultation. Sorry, Nicole, back to you.
Yeah, and I think just maybe the last thing I want to say on this is that it also, even though to us as independent, objective people who have I like to think, a lot of experience in these types of schemes, I actually recently had a mixed use scheme in Cape Town, who, again, it's a residential commercial, but it's unfortunate that the commercial has a 26% PQ in the scheme. So, there's been a history of when work has been needed to, like, perhaps the residential section or things like that, it's been blocked by the PQ of the commercial owners. And the commercial owners proposed a Section 11.2 rule, which is the component, our recommendation of a component type split rule in the management rules. I'm not going to get into where the Section 11.2 rule belongs, because that's a whole nother webinar. But and when the trustees were approached with it, they actually didn't like this proposal at all. And again, I was quite shocked, because to me, I was like, are you guys sure? Like, this is pretty successful in almost every other like mixed use building that I've worked in. They all are actually trying to move towards like this component split rule. And the trustees let me know that actually in our building and with our history, it's actually not going to work, because essentially what they're looking, or what the commercial owner is hoping for, is they would be able to do work within the commercial component without then the residential component having any say over it. And of course, because that's been historically an issue in the past, the body corporate is obviously not in favor of it. However, I recommended that it shouldn't be a trustee decision, something that they should pose to the members at the next AGM. But if members are not in favor of it, then they are not in favor of it. And then this scheme will just continue to operate and govern as a single body corporate. So I think just what I wanted to say is that this is a really good example of how it should have been set up in the beginning, because now after the fact, because there is this us versus them, and they are just going to continue to get away with things, it's not possible to bring this element into a scheme like this. So I think that that's also something to take into account if you think that, oh, this is something that like would really work in my scheme. It might practically be a really good idea, but, you know, more subjectively, you need to take into account the history of your scheme and, you know, the people that live there currently, because I don't think people take into account how a change in ownership in schemes has really changed community scheme dynamics recently. I know Zerlinda and I and TVDM have recently been dealing like with a few issues where, you know, younger people, different cultures are moving into community schemes, and, you know, it's been governed a certain way for so many years, and only now people are saying, actually, I don't actually like what's happening here. And of course, often the response is, well, we've been doing it like this for many, many years. So that's also something to think about with rules, is that even though you've had a specific rule or a way of doing things in the past and it's been working, schemes need to take into account that with the change in ownership, you know, younger generations, different cultures, diversity coming into community schemes, people are probably going to need to start looking at stepping away from like that status quo, the traditional way, or the traditional rules that you would just have in a stock standard body corporate. Yeah.
One of the matters I see Aubrey mentions the scheme. So I didn't want to actually mention the scheme, but it is what it is. It's now mentioned. So in this scheme, what they have is they had a share block. So, for example, and I saw there was somebody else that also mentioned that they had a caravan park that formed part of the scheme. So traditionally, this was the caravan park that was the share block that formed part of the scheme. But over time, there were also then other sections built, and the sectional plan was amended. And then in 2012, these units were actually transferred to the share block, and people were then given the right to occupy in terms of the share blocks share agreement. And in this specific instance, the caravan park didn't pay its levies. It was not as successful as one would have expected or hoped, and didn't pay levies. And that resulted in the share block now being liquidated. So you're sitting with a share block inside the body corporate that did not pay levies. Now this has been liquidated, and you have people that have sections in that share block where they have the right of use for the whole year. So in essence, it is a primary residence. They are staying there, and there's a liquidation that takes place in respect of the properties that they own, but it's not a property, it's the company that's being liquidated, and they will lose their primary residence without actually being notified, because the directors moved for the liquidation of this. So yeah, whose scheme is it? Whose property is it? It's a very problematic matter, and I think DTB is busy with that, where they are now going to try and set aside the liquidation on the basis that these were primary residences and these people were never notified that they're going to lose their properties, because in essence that's what they are losing, but they actually only have a personal right, the right to occupy, and they're not the owners really. They don't have ownership of those properties, but according to them they have. That is what they feel they have. But so multi-layered schemes, difficult things, lots of problems.
Yeah.
The next,
There's a question that just popped up, and I know I'm ignoring a whole bunch of others, but the person asked, you know, if it comes to light that if 2 body corporates have been managed as one, and the majority of owners are in favor of keeping that way and not splitting it into 2 body corporates as they should, is that acceptable? You know, unfortunately, we can't agree to do the wrong thing. It's not acceptable. And to retrofit it or to do the right thing post fact is actually very complicated, and it's not as simple as a majority owner decision. You know, you are 2 different entities, and you've got 2 different sets of statutory requirements. You can't just ignore that. The only way that, I mean, and this is going to pick on the topic after this one that we're going to talk on now, but you know, your title deed conditions and what you had the intention of purchasing into, and what the developer's intention is, and what the local authority has given permission for. So it's not as simple as just, you know, sticking to what we're doing. I know that the outcome of the meeting that you went to was that indeed, you know, well, we've been doing it for so long, no one's got a problem with it, let's just continue. But
and also we are the majority that want it like that. So at the end of the day, that's what we want, and the majority wants it. However, your problem is that, in my opinion, I believe that each and every owner will have to agree to that. And if you can't get each and every owner to agree to that, then you have to place the scheme under administration, and then the administrator can make that decision, because he steps in the shoes of all owners and trustees and the whole body corporate. So then that decision can be made, because that's a single person that, or company or whatever that does the administration, that then can make that. But then you need to make sure that your court order allows for the exercising of those rules, because in the instance where we tried it, CSOS then came back and says, but your order does not give you authority to do so. And we are taking away rights of owners in that regard, and we can't allow that unless you specifically ask for those rights in terms of your initial court order. And then you will have to, but we've learned, I mean, now in future, we will make sure that the court orders do include that, to make sure that one can make those decisions, if that is the right decision to make in respect of a scheme. And I believe the one in Ilova would have been proper to have that in there, so that one can split all this multi-layers out and have different levies and different contributions and so forth in respect of them. Yeah.
Yeah. And, you know, Nicole mentioned earlier, you don't know what you don't know. So, you know, becoming an administrator for a scheme, I think, is probably also one of the most difficult things, because you get approached or you get appointed, and you are then tasked with trying to unravel whatever mess you're stepping into. And this might only become apparent afterwards, you know, now you don't have those powers that you didn't even think that you would need. So it should almost be an automatic that an administrator, and that's always been my opinion of an administrator, is that your executive managing agent steps into the shoes of trustees, and your administrator steps into the place of trustees and owners. You know, and it's not an easy decision that the court makes to appoint an administrator, nor is it an easy decision that an applicant takes when they approach the court for an administration application. So it should, in my opinion, be automatic that, you know, we have all the powers vested in us that are going to be required as we unravel this puzzle and try to, you know, fix the issues. I think we did talk about this topic, Master Association and Property Owners Association, while we were discussing, you know, this hybrid between body corporates and homeowners associations. Looking at the time, maybe we want to jump onto the last topic, which is the title deed conditions. Oh, there we go. We spoke. I think we spoke about all of them sort of higgledy-piggledy. The linked body corporates, the 2 body corporates that were linked as one, I think that's the prime example of it. Willie, this is your area of speciality. The only thing that I'd like to say from our side, and Nicole, you can jump in, is that you can't look at any one of these documents or provisions in isolation. You can't say, okay, fine, my agreement of sale doesn't mention a homeowners association, therefore I'm not a member. or the constitution doesn't mention there are multiple entities, therefore the multiple entities are not members of the homeowners association. You have to look at all of them. But the most important, in my opinion, is the title deed condition, because the title deed condition is going to be what binds successors in title, what binds the homeowners association or the body corporate from not making amendments to their governance documents to do away with what the title deed requires, and then of course is not going to allow a sale and a registration that is in contravention of the title deed condition. And then of course any title deed condition that is not put in place by the developer, as Willie rightly says, does require the written consent of every single owner, which is where it becomes tricky.
Yeah. So to jump into this, one actually need to understand the difference between the real rights and personal rights. So I think that's the start of that. And a personal right is only enforceable between the parties that contract, or where the rights arise between the parties. So if Zerlinda and I agree on something and she must pay me, then I have a personal right. If I've delivered the pen or whatever I'm selling to her, then she must deliver the payment price, and that is a personal right. So I have that right to recover from her, and that is then the right. But what I get when she has passed the pen over to me is I become the owner of that pen, and I'm the real right holder of the pen. So I'm the owner of that pen. So I've got different rights. So those are the two different rights at play here. And when you agree in your conditions of sale between the parties, then those rights are just enforceable between those parties and not enforceable against the whole world, where my real right or the limitations of my real rights are enforceable against everybody else. And that's the difference. So when you then set up your township establishment or your homeowners association and so forth, then it is required that the conditions of title then be amended. So when this township is registered, there will be then a condition of title, or in respect of your sectional title properties, you will be a member and you will be obligated to then contribute. And when you pass ownership to somebody else, then you have to, all people that pass from one to the other is then obligated to contribute and to be a member of that association. So your real right in respect of that property is limited in the sense that you have to be a member and that you have to pay and so forth. So that needs to be incorporated into the title deed. And when one passes transfer, one then needs to make sure that those conditions of title is then passed forward in every transfer that you pass on to the new purchaser. And that's also part of what the deeds office do, is they make sure that those conditions are incorporated in there and that it corresponds with the previous title deed, and that is in fact in place. And in that way, you then ensure that everybody that subsequently purchase is obligated to contribute and is a member and is obligated to comply with the rules and so forth of that homeowners association. Where if you, for example, buy in what we see here in Gauteng, where we have road closures, then everybody agrees in the specific suburb, we're going to close the roads, we're getting permission from the council to close the road, and we're all going to contribute to the security. Those rights are only enforceable between those parties that agreed and with the homeowners, or whatever. They're not really a homeowners association, they are an enclosed suburb agreement. And those are then only enforceable between those parties, because it's not included in the title deed and it is not enforceable on subsequent parties. So unless the person that then purchased also agrees to be obligated to contribute, you're not going to be able to actually enforce that. And you might then get more and more people that then purchase into that enclosed area, but that don't contribute. And that's the difference between having it in your title deed and only have it in an agreement where it is enforceable between the parties. Zerlinda, Nicole, anything else that you want to add to that?
I would just also add that specifically with bodies corporate, I would just also say the section the Section 11.3b conveyances certificate is also a pretty good clue, especially in the multi-layered developments. So that's always a very good giveaway, and it usually mimics what's the condition on the conveyances. Conveyances certificate mimics the condition that needs to be placed in the title deed.
Correct.
So that's just another important thing to note. And also, I don't want to say that they're not as popular, because it's always a hit and miss, but also things like registered exclusive use areas for bodies corporate, they would also be noted on the Section 11.3b conveyances certificate, as well as if the prescribed management and conduct rules were not used with the opening of the scheme. So there's also some good information that you can get from the Section 11.3b conveyances certificate. However, and I say however, with older schemes, unfortunately, we found that things like the certificate of establishment and Section 11.3b certificates, if it's not at the deeds office, it's almost impossible to get a hold of. And I know at least I know of like 2 or 3 schemes where they haven't been able to find it, but at least it's been present on the title deed condition. So then, they've made an educated assumption and accepted it as fact, and then move forward and cementing it in things like their management rules moving forward. So that's just one thing I wanted to add.
Can we just answer that question that's is it on the screen? I don't know if I've put it on the screen, the one that says, so if I understand correctly, if 2 schemes which have been managed as one for a very long time, and the majority of owners are in favor of keeping it that way and not splitting the 2 schemes, that would be acceptable.
That's what we spoke about, Nana, but it's not just okay for the majority, No,
it's everybody. You have to have the buy-in. So the moment that one person says, well, I'm not happy anymore, then you've got a problem. Then
or the new person coming in, that's normally where it happens. It's the new guy coming in that starts asking all the questions. The other thing on that Section 11.3b certificate, I don't think you said, was the developer's reserved right to extend the scheme is also on that. So that's a really super important document. So it's a Section 11.3b in terms of the Sectional Titles Act, that certificate. And then you also get the Section 11.3e certificate, which is regarding the rules. So it's any developer's conditions that were put into place at the start or the opening of the sectional title register. That's really, really important to understand. And just because, well, you mustn't assume that what is on the title deed is going to reflect on the Section 11.3b certificate or the sale agreement, because very often when we're dealing with a multi-layered scheme with multiple body corporates, each one of those body corporates could have a Section 11.3b certificate that says something different. We also find that with this Regulation 6 setup, we often suggest that when you have a body corporate in a overarching association, that not only the body corporate as an owner of an IRF is a member of the association, but the individual unit owners in the body corporate should also be members of the association. And that ties them to comply directly to the constitution and the rules of the association, as well as payment of levies. Collection of levies or enforcement of rules can be delegated from the association to each individual body corporate, but it's better to tie both the owners of units and the body corporate, but that's not often the case, not often done. So yeah, it's quite complicated. I remember the first time I had to do it in practice was when I was with Paddocks, and I've tried to get Prof. Paddock to take the matter over from me, and he wasn't having it. He said I needed to learn, and he would teach me every single step of the way. And I remember being absolutely fearful of this instruction. But at the end of it, it felt like I had accomplished a very big, feat. And after that, I thought, sure, okay, well, if I could do that, I'm sure I could do the next thing. I'm sure I could do the next thing. We always say that sectional title or community schemes are simple or consumer friendly. Sometimes it does get quite complicated, especially when you're dealing with more of the conveyancing aspects, the developer aspects, which is important for anybody buying into a new development or even an existing development. They need to understand what they are buying, what they are buying into, not only from a body corporate perspective, from an HA perspective or a multi-layered development as well. So yeah, that's my 2 cents, Willie.
Thanks. So interesting subject with lots of problems and lots of litigation flowing from it. or possibly that can flow from this. So definitely when you're buying into these multi-layered schemes and homeowners associations with homeowners associations or homeowners associations with bodies corporate in them and so forth, make sure that you understand all the obligations in that scheme and understand what you can and cannot do. Otherwise, there will be some problems in that regard. Yeah, thanks, ladies. I really appreciate it. Very
Thank you.
interesting subject, and some nice working with you guys in respect of these things.
Always, Willie.
So
Thank you.
yeah.
Thank you for teaching us as much as you do, and thank you for
No,
always
I
being
don't.
available.
No, you guys are the clever ones.
No,
I'm
man,
learning from you guys.
Thank you for the flattery. And we'll see you in Cape Town soon.
We'll see you in Cape Town. So the people that are still on here, we've got the Let's Get Physical in Cape Town. So the people that are in Cape Town, if you haven't registered as yet, register as soon as possible. Don't know how many spots is still available. We have the Let's Get Physical event on the 10th of September in Cape Town. And the usual panel of experts will be there with the ladies from TVDM and Aubrey that's on here, and Mike Addison, and all the other clever people that assist in this fantastic event and that collaborates in this. We are so lucky to be part of a great team like the Let's Get Physical team that do the physical meetings and the physical training. So yeah,
awesome.
We'll
There's
see
just
you
a
guys
question
there.
as to where they can register for the Let's Get Physical events. It's on all the social media posts. We've sent out quite a few.
I think it's on
Zfin's
newsletters and
things.
on Zfin. So if you look at on the Zfin website, you'll probably see it. But all of us are sending it out. So if you look on Sectional Title Living South Africa.
Zfin just reshared it on LinkedIn as of 1 minute ago. So
okay, fantastic. Okay.
Awesome.
So yeah, so if you look on this TVDN website, the Zfin website, the Stratafin website, AdSure's website, Multiprof's website, and Facebook pages, Facebook pages, correct. Then it will definitely be there, and you can just click on the link and register for that. And it would be great to see you guys there. And then for all those that have not registered, the free trustees training and owner training on the Stratafin portal, please guys go and register and learn from that course. It's a 12-module course that's there for free.
Yeah. Awesome. Thank you so much.
Thanks, guys.